Well, welcome everyone. Thank you so much for joining me. I'm so happy to be here for your employment law session. My name is Lior Samfiru. I'm the employment lawyer, and I am here on this live session for you, with you, to answer your questions, to tell you about employment law, and to solve your workplace problems. I'm one of the founding partners of Samfiru Tumarkin LLP. You can find us across Ontario, BC, and Alberta. And usually I'm here on Wednesdays. Today we're changing things up on the Friday with you live to answer your questions, to help you understand your workplace rights. So we all have jobs, right? So we all need to understand what our rights are, what to do if our boss is mistreating us, what to do if our job is changed, if we lost our job, if we're put on a temporary layoff, if we have to go off work sick. What does that mean? How do we do it? What does the law say? And how do we deal with our employer in those situations? Well, right now you can ask the question. You can tell me what you want to know, and I'll answer it. I'm not going to lecture you on the law. I'll just tell you what you need to know. I'll make sure that when you turn off the device that you're watching right now, you'll know more than you did before you joined. So take advantage. I'm here for 30 minutes with you, for you. I can talk about employment law all day. I don't need questions to do that, but it's so much better if you ask questions, if you tell me what the issue is and allow me to help you. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And let me give you some other contact information for me and my team before I get started answering questions. If you want to connect with me at any time and my team, again, in Ontario, BC, and Alberta, so very easy to do that. All you do is you go to employmentlawyer.ca. Again, employmentlawyer.ca. And when you go to employmentlawyer.ca, the phone number is there. The email address is there. If you prefer to fill out a form and to have my team call you, it's all right there. Okay, so employmentlawyer.ca. But right now, you have me here. If you want to connect with me personally, just ask the question right now. Ask me what you want to know, and I will tell you. I'll make sure that you get those answers. So you have plenty of time. You have a little box on the screen. Type your question in there, hit enter, and I'll read it and I'll answer it. All right, we know what we're here to do. Let's do it right now. Let me start answering some questions. If you want to, again, connect with me, employmentlawyer.ca. Right now, live, let's talk. All right, first question of the day. Thank you, and that's from AK. I was let go from my job last week. Before that, I was placed on a 3-month performance improvement plan. It kept getting extended. During this period, I did not have any major hiccups at work, and they would not give me an end date to my performance improvement plan. I was let go from my position and offered 2 weeks per year of service in severance. Should I be filing a lawsuit for more? So let's break this down. Ultimately, the fact that you're on a performance improvement plan doesn't mean that the company can let you go for cause, okay? They can let you go with severance, what we call a without cause termination. Keep in mind, of course, that your employer can let you go with severance pretty much for any reason. Even if you've done nothing wrong, they can let you go as long as they pay you your full severance. So for you, it's not really about the performance improvement plan anymore. You've been let go. Remember, just because you're on a performance improvement plan does not mean you can be deprived of your severance. So you're out severance. So the question is, how much severance? So here's the thing. It's not 2 weeks per year. It's much more. Now, AK, you haven't told me how long you've worked there. You haven't told me the job you were doing, your age, so I can't answer that. I need to know your age, your position, and the length of your employment. But it's a lot more than 2 weeks. So I want you to connect with me and my team. We'll assess how much you're owed and we'll get you what you're owed. It doesn't mean you have to file a lawsuit. And usually we can resolve this much quicker even without having to file a lawsuit. Not at all. So these things are not difficult to resolve. You are owed more than 2 weeks per year of service. So the next step, very easy, to connect with me right now through employmentlawyer.ca. Phone numbers there, email addresses there, and I'll be able to help you. So absolutely, let's make that happen. Let's have that conversation. Again, employmentlawyer.ca. All right, fantastic question. Way to start us off today. Thank you for that question. If you just joined us, my name is Lior Samfiru. I'm the employment lawyer. with Samfiru, Tumarkin, LLP, and I am here live with you answering questions. I want to get more of those questions answered. I see some have come in right now. Let me answer them, all right? More questions, but ask yours. You got time. All right. Jammin has our next question. I believe I have a constructive dismissal. Then I've seen your show since December. I'm changing job. Okay, there's no question there, Jamie, so there's nothing for me to answer. You can ask your question if you have it, or you can connect with me and my team through employmentlawyer.ca. Again, employmentlawyer.ca if you want to have a private chat, or you can ask a question right now, and I'll tell you what this all means. All right, Russell has our next question. The employer changed my pay from 40 hours a week to billable hours only. This effectively changed my income to about 10% of the last 21 years. So would that be a constructive dismissal? So what I'm trying to understand, Russell, is has your income been reduced by 10%, or is it now only 10% of what it used to be? If it's 10% of what it used to be, man, of course that is a constructive dismissal, 100%. That's illegal. Constructive dismissal. Now, if it's been reduced by 10%, it's borderline. Usually when we get 12 or more, that's when constructive dismissal territory. So I'd want to understand better what they've done and how that's impacted you. Now, keep in mind, for those that don't understand or know what a constructive dismissal is, a constructive dismissal happens when your employer makes a significant change to the terms of your employment, like a pay reduction, like a demotion, a relocation, taking away parts of your compensation, etc. That is a constructive dismissal, which means you can consider that a termination of your employment and get your full severance. Now, Russell, I see that you're saying that your pay has been reduced to 10% of what it used to be. That is 100% a constructive dismissal. It couldn't be more of a constructive dismissal if we tried. So this is a constructive dismissal. It would be insane for anyone to accept that, essentially a 90% pay reduction. You have to treat this as a termination. Let me give you another reason why you want to treat this as a termination. Let's say you accept this and you continue working, and let's say 3 months from now, they let you go. At that point, the severance that they have to pay you is calculated on your pay at that time, which is only 10%. So you could be losing tens of thousands of dollars in severance. You want to get your severance now because you can get it based on your full pay, your 100% pay. It's illegal. Your employer can't reduce your pay that way. Not possible. So you can either accept this. Frankly, that's a very bad idea. Or you can consider that to be a termination and get severance. Now, Russell, before you do anything, okay, don't walk into your boss's office and say, I'm out of here. Don't do anything before you reach out to me or my team so we can have a private discussion and dot our I's and cross our T's, and we'll talk about how to pursue this. Connecting with me is very easy. Just go to employmentlawyer.ca. Again, employmentlawyer.ca, and I'll be able to help you. So please do that. Do that right now. And let's have that chat. Absolutely a constructive dismissal. Nonsense for an employer to think that they can get away with that. By the way, Sherry just asked if she can ask a question related to disability law. Absolutely, you can. You can and you should. Let's talk about that right now. By the way, if you've just joined us, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. And as you've seen me do for the last 10 minutes or so, I've been answering questions live here from anyone and everyone that wants to know about their workplace rights. Very important topic. If we didn't have jobs, employment laws wouldn't matter. We have jobs. We are working. We need to work. Well, if we work, then we also need to know our workplace rights. A great place to start is right here, right now, with your questions. So don't be bashful. There's no bad questions. I see more have come in. I'm going to answer them right now, but I want yours too. I don't want you to turn off your computer today without asking the questions that you have, okay? Let's make sure you get those answers. All right, let's continue answering questions. Let's see where I left off. All right. Mian says, I used this firm. They know their stuff. They take a chunk of change at the end from you, but you still come out ahead. Well, here's the thing. Most of our clients prefer that we take a percentage of what extra money we get for them. And in most cases, we negotiate for the company to pay it in addition. So that's how that works. So thank you for that. Jammin has a question. They cannot change your job description or job task. I believe you explained constructive dismissal. Again, you're not asking a question, so I'm not sure exactly what you're asking here, Jammin. If you have a question, ask it. A constructive dismissal happens when an employer makes a significant change to the terms of your employment. If it's a demotion, that could be a constructive dismissal. But if, for example, if you operate a machine and they say from now on, you're not going to operate this machine, you're going to operate a different machine, that's probably not a constructive dismissal. So I need to know some information before I can tell you if it's a constructive dismissal. Okay, so you haven't asked a question. If you have a question, please ask it. I'll be happy to answer it. All right, let's see. More questions have come in. Thank you. Ask your questions, please. You got time. No excuse. Don't ask me at the very end as I'm saying goodbye, because then it's too late. Now you have time. You can take your time. I'll get the answer. I don't have to rush through it. So take advantage of me being here. All right, next question comes to us from Greg. I work for a production plant that have a job lined up that requires me to start ASAP. It says on my current contract that the employee may resign by providing 2 weeks notice. I don't want to work here anymore because my boss and other workers have harassed me verbally. I have been denied the refusal. I have been denied the refusal of OT. I'm not sure what that means, and have been forced to work them. I can't take this anymore, and I'm just worried that they might sue me. Do I have to wait 2 weeks? My best advice, if you can, give that 2 weeks notice. Okay, my best advice. It's the easiest thing to do. If you don't, will they take legal action against you? Probably not. Okay, probably not, but it's possible. So if you want to have no risk, no issue, try to see if you can give that 2 weeks. If you can't give 2 weeks, if you can only give 1 week, at least give that as much as you can to minimize the likelihood of legal action. It's very difficult to successfully take legal action against an employee that doesn't give enough notice of resignation, but theoretically it is possible, okay? And I have seen that happen. So best advice I'm going to give you, if you are able to give 2 weeks notice, give 2 weeks notice. If you can only give 10 days, then give 10 days. But as much as you can, the more notice you give, the less likely it is that there's any concern about a legal action, okay? So hopefully that makes sense, Greg. If you need any advice, if you need some follow-up, easy to do, reach me through employmentlawyer.ca. Again, employmentlawyer.ca. So let's see. Jammin, I think, finally has a question. Says, if the job changes from mechanic to road crew, it's a big change. So that could absolutely be a constructive dismissal, but I'd want to know the differences between the job. Is there a difference in hours? Is there a difference in pay? How does the job actually change? So obviously, the title is different, but I need to actually understand how that affects you. If it's a significant change in terms of either responsibility or pay or hours, it can easily be a constructive dismissal. So here's the best advice I'm going to be able to give you, Jammin. Reach out to me and my team through employmentlawyer.ca. Again, employmentlawyer.ca, so we can understand exactly what you're going through, and that we can advise you appropriately and help you if it is in fact a constructive dismissal. Again, for those that are just joining us, constructive dismissal is a situation where your employer makes a big change to terms of employment, responsibilities, hours, pay, etc. That may give you the right then to consider your employment as being terminated and force your employer to pay you severance. And of course, that severance can be as much as 24 months pay. So we're talking significant amounts of severance potentially. So hopefully that helps. And if any follow-up questions, reach out to me. Again, I'm Lior Samfiru, employment lawyer. I am now answering more questions. I'm live. Ask yours too. All right. Oh, Sherry has a bunch of things here. I was involved in an incident in the workplace, which resulted in my superior being terminated in November 21. It was determined that this conduct amounted to harassment, sexual harassment, and a poison work environment. I tried to stay working, but eventually had to go off on short-term disability and long-term disability. The HR person advised me that I could go on short-term disability. Okay. My group benefits provider advised me recently that my benefits have been extended to October 2025. Again, there's no question here, so if you have a question, please ask me. All right. So Jammin, my team is some of the best in the country. Any lawyer on my team that you're going to speak to, you're in great hands, whether it's me or someone else. So you have our contact information. Contact us again. We're not going to reach out to you. Contact us if you need my team's help. Again, employmentlawyer.ca. If you've just joined us, I'm Lior Samfiru, the employment lawyer. I'm here live answering your questions, not someone else's questions, your questions. So please ask them. Renee has our next question. Renee. Okay. Can a company say, Mr. Samfiru, we're not paying what you're requesting, delay the process, and rely on the duty to mitigate to pay less? Well, it's our job, Renee, to make sure that the matter gets resolved quickly and on the best terms. Remember, your company is not going to be happy to pay. They're going to try to find ways to avoid it. But if we know what we're doing, and we do know what we're doing, we'll make sure that they can't delay. They can't avoid paying you what you're owed. Okay, so that's why you got to call us. And here's something that I'm not happy about saying, but I see this often. At least once a week, at least, we get contacted by someone that spoke to someone else and they were given some promises and things didn't work out. And they're coming to us to help them. Say, I don't think my other lawyer was helping me properly. And they're coming to us to try to fix the problem. I don't like that because usually it's too late to fix or it's too problematic. So I try to avoid that. If you have an issue, let's talk. Okay. If you're not happy, you can go somewhere else. But we're the biggest employment firm in the country for a reason. We know what we're doing. Our name on the letterhead has all the effect. So Renee or anyone else, if you have an issue, a problem, a question, employmentlawyer.ca, the place to go to, and let's make sure that we get that help that you're needing. Now, you've heard me talk about severance a few times on this session already. Let me give you another tool that you can go to anytime to find out how much severance you're owed. Remember, I told you it's not a week per year of service or 2 weeks per year of service. It's not that. So how much is it and how can you find out? Easy. All you do is you go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. You see that address on the screen. And when you go there, you just click on the severance calculator. That's it. Done. Severance calculator. It does what the name suggests. Over 2 million people have used it. And you answer a few questions, and it tells you how much severance you are owed. It calculates it, whether you're owed 4 months or 18 months or 24 months. It calculates it for you. By the way, it's completely free. It's completely anonymous. I know some people don't want to put in names. You don't have to put in any names, okay? It's completely there for you anonymously. And you can also contact me if you want directly from the severance calculator. You'll be shocked by how much you're owed. It's a lot more than you think. You may think, oh, I'll probably be owed 8 weeks severance. It's probably 12 months. Okay, so check out pocketemploymentlawyer.ca. Go to the severance calculator and check it out for yourself. It should be the first place you go to if you lost your job. All right. So right now we are here. Of course, I am here live answering your questions. I am here live telling you what you need to know. All right. Ask your question. Let's make sure you get answers with me, Lior Samfiru, the employment lawyer. Let's see. Sherry has finally asked a question here. Sherry's on long-term disability, and she says, my group benefits provider is asking me if I'm going to make a WSIB claim. Can I apply or should I apply? Yes, you should apply for WSIB. And you don't want your insurance company to cut you off because of the fact that you didn't apply. Now you should apply. It probably won't get approved, but at least you can tell your insurance company that you did it. But the best advice I'm going to give you, we have a whole team at the office dealing exclusively with disability issues. So you can reach out to me and I'll connect you with one of my team members. Again, you can do that through employmentlawyer.ca, and I'll make sure that you get that help that you need. When it comes to these disability issues, it can be tricky. And you feel very vulnerable. You can't work. You need that income from the insurance company. They're maybe threatening to cut you off. They're denying you. You got to deal with this right away. Okay. We have some of the best disability lawyers in the country at the firm. reach out to me again, employmentlawyer.ca, and we'll get you that help that you need. All right, fantastic. We got some time. You've got some time to ask me some questions. I'm Lior Samfiru, the employment lawyer, and I want your questions before I end the session today. So what are you waiting for? Now's the time. Ask. Carlos has our next question. I was just sent home from the company that I've worked for 8 years with the promise of a temporary layoff. When I look at my record of employment, which they sent me, it says not returning. How do I apply for my severance pay in this situation? It's extremely easy. You call us, right? You reach out to us. You can do that now through employmentlawyer.ca. And you don't apply. You simply, and you get it. You demand it, and we deal with it. So it's not up to the company. And by the way, even if they put you on a temporary layoff, that's not allowed. For most people, a temporary layoff is a constructive dismissal. Remember what I said to an earlier person, that they can't reduce your pay by 90%. Well, what's a temporary layoff? It's a reduction of pay of 100%. So your employer doesn't have a right to do that. Whether it's a temporary layoff or a permanent one, you are owed severance. So what you're going to do, Carlos, is going to connect with me through employmentlawyer.ca. Let me give that again, employmentlawyer.ca, and I'll help you get that severance. As simple as that. Thank you for that question. All right. XO Secretly Talks. Nice name. Good stuff. Next question. I got terminated for no cause, and now that I made a claim, they have made false accusations. Not unionized. It's a not-profit. Well, I mean, you've made a claim. That means you're working with a lawyer. So I don't want to get involved. If you have a lawyer, your questions should be to that lawyer. If you're working with a lawyer, that lawyer should know exactly how to deal with that. Okay, because this happens often. We know exactly how to deal with that, how to get rid of those accusations, how to resolve the matter and get severance. So if you have a lawyer, you need to speak to that lawyer. Otherwise, happy to connect with you. But if you have a lawyer, the question should always be to that lawyer. All right, let's see. Mian makes a very good point that if you're unionized, a lawyer cannot help. You're absolutely right. Everything you hear me say today or anytime only applies to non-union employees, non-union. If you're a unionized employee, only the union is allowed to help you. You cannot hire me. You cannot hire another employment lawyer. It has to be the union. Even if the union doesn't really want to help you, or if they're not doing a good job, there's no other options. You're not able to say, well, my union's not helping me, so I'm just going to hire a lawyer. Can't do that. It has to be the union. The union is the only one allowed to deal with your employer. Okay? Even if you've been let go and you don't work for the company, it's still only the union that's allowed to do that. Okay, so nothing that I say here today, nothing applies to a unionized employee, only non-union. All right, let's see. Dean has our next question. Dean is joining us from Facebook. If there was an incident of workplace violence and both parties involved are still in the workplace, but there are accommodations in place, but the workplace violence continues to happen, could there be an action taken against the employer? Absolutely. The employer's primary obligation is to protect its employees. With respect to harassment, to violence, absolutely. An employer has to protect their employees. If they know there's an issue and they're not fixing that issue, that could be a breach of several statutes. That could be a constructive dismissal. In some situations, depending on the circumstances, it could be a human rights violation. So it's not legal. So obviously the devil is always in the details. I would want to know what actually happened, who was involved, what was the employer told, and how did the employer respond. But if your employer knows that there's a problem and it allows that to continue, it allows violence to continue, it hasn't fixed that issue, man, oh man, that is illegal, completely illegal. No one should have to put up with that. So Dean, if that's your situation or the situation of someone you know, you got to reach out to me as soon as possible. Again, through employmentlawyer.ca. Again, employmentlawyer.ca. All right, let's see. Thank you for that question, by the way. I'm going to continue answering questions. Let me just make sure I have them here. Fantastic. Russell. Okay. Russell says, I have asked my employer for my record of employment in order to apply for EI to try to confirm my lost wages, even though I have not actually been terminated. Your employer is not going to give you a record of employment if you're not been terminated. They're not. Okay. So you don't have the option to get that record of employment. The only thing you can do is you have to now make a decision. Do you continue working, or do you consider your employment as being terminated? If you want to consider your employment as being terminated, we have to get involved. And then we will get you your record of employment. But your employer is never going to give you the record of employment because from their perspective, you continue working there. So you only have two choices. Do nothing and continue working, or treat this as a constructive dismissal. There's really no third option. If you want to consider this a constructive dismissal, or at least discuss what's involved in that, you need to connect with us, but you need to connect with us right away. If your employer has made these changes and you continue working and you just don't do anything, you're going to be considered to have accepted it. And once you've accepted it, you can't go back. So you only have a small window to do something about it. So Russell, you got to contact us today, my friend, okay? employmentlawyer.ca to do that. Again, employmentlawyer.ca. All right. Mien has a question. I was offered 2 weeks' pay from the small company I work with many years. Lior's firm told my firm I'm entitled to a year's pay. Yeah, don't believe anything your employer says. That's absolutely correct. Good advice. Next question is from OK Coconut, another great name. I have worked at the same company for over 5 years. The company is like a family, and we're all become good friends. Last year, one of our best employees handed in his notice. While his exit was done maturely and without any intention of taking clients, it caused a huge upset with our boss. I've remained good friends with this ex-employee. Last week, my boss called me into office and advised that further communication with this person would be grounds for dismissal. What are my rights, and does he have a leg to stand on? So remember what I said at the very beginning of this session, that your employer can let you go pretty much for any reason as long as they pay you severance. So this is one of those things. Your employer can say, if you speak with Bob, I'm going to let you go. But that would be a without cause termination, meaning you would have to get paid severance. It's not a situation where they can say, aha, we told you not to do it. You did, so we can let you go for cause and pay you nothing. Absolutely not. There's another silly example that I like to use. Your employer can say to you, Bob, you drive a blue car. We decided we only like people with red cars, so we're going to let you go. Now, of course, that's silly because no employer would actually do that. But from a legal standpoint, they could, as long as they paid proper severance. So, okay, Coconut, can they let you go if you speak with that ex-employee? Yes, they could, but it would be a without cause termination and you would be owed your severance. Now, you say you've been there for over 5 years. I don't know exactly the number of years, and I don't know the job that you're doing, but you certainly will be owed at least 6 months. It could be much, much, much more than that. Okay, so that's what's at stake here for you. You have to decide what's best. But remember, your employer can let you go even if the reason is dumb. They can do that, but they have to pay you your full severance. That's the key. All right, guys, I think this is the time that we have today. Lots of questions today. I love it. I really appreciate having the opportunity to answer them. If you are wondering who I am and how to reach me beyond this session, let me give that to you one more time. I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. And now that the session is ending, you can still reach me and my team anytime. Just go to employmentlawyer.ca. Again, employmentlawyer.ca, phone number, email, everything is there. I'm Lior Samfiru. Thank you so much for joining me. Thank you for the questions. I'll be back here again soon, so we'll see you then. Take care.